Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Today we're going to talk about the trial of Greg Leone in South Carolina. I'll have more on that in just a moment. One of the things that often comes up in the context of a murder trial is a claim of self-defense. Now, self-defense is a valid legal argument where there is a present, immediate, unavoidable, deadly threat, and you have to act in order to prevent death or serious bodily injury, either to yourself or to someone else who would be privileged to act in the same way if they could. So, for example, if your wife is being beaten by a burglar in your house, there is absolutely nothing that prevents you from, in most cases, shooting that burglar who is trying to attack your wife. But you have to make sure that everything else is appropriate and that the burglar is not actually your wife's secret lover. Because if you do that, you are going to come up on the radar of the prosecutors as someone who set this whole thing into motion in order to establish a defense of self-defense when in fact it was actually murder. So Greg Leone is a restaurant owner in Lexington, South Carolina, and he apparently believed that his wife was having an affair. And the guy that he was having an affair with, I'm not sure he was on the up and up. They say he had numerous different IDs in his pocket when he was killed. So he may have been someone who was on the wrong side of the law. But of course, just because somebody is out there and doing criminal things doesn't give another person the right to take them out. As I understand it, and I have to be clear about this, there is no video from the courtroom. Although still photographers are allowed to take still photos in the courtroom, there's no audio recording and there's no video recording in this case, unlike the Murdaugh case. And that is going to hamper any kind of serious reporting on this case. Because a viewer asked me to do this video, I felt the need to go and do some research and find out. Now, there are a number of things about this that are interesting. The first being that when the assault took place, when the shooting took place, the man that was shot was in the same car with the shooter's wife, with Greg Leone's wife. And the claim that Leone made was, I thought this guy was attacking my wife, so I had to shoot him. And there is some question about whether or not that's legitimate, but that again is for the jury to decide. This is one of those cases where a client sort of feels like he can do a little something to help his lawyer out. And whenever somebody does something like that, it almost always works against the case. In this case, according to the South Carolina Law Enforcement Division, essentially what happened was he asked another woman to testify that this guy was a bad man, that he had done threats and that sort of thing. And that person went to the state law enforcement division, SLED, and said, hey, this guy wants me to lie. And they set her up with a wire, and she called a woman, and this defendant was supposedly on the call. And they agreed that this woman should tell SLED a number of things that clearly weren't true. Now, interestingly enough, the cross-examination in this case, I think, would have been a really good thing to have seen, because it appears that the cross-examiner is doing a really good job of taking points off the board that the state puts up. One of the things that the state pointed out is, hey, nobody has said that that's my guy on the tape. And whoever is on the tape didn't offer any compensation. The woman who was on the call offered compensation to this person to testify falsely, but the man who was on the call, which they do not admit was their client, did not. So even though he might have been part of it, he didn't commit any overt act or do anything that would lead to conspiracy or another charge of witness tampering. Although you could certainly make the argument that just by being on that call, he was part and parcel of witness tampering, and that will not look good to a jury. And the reason it won't look good to a jury is because a jury assumes that if indeed you have been tampering with a witness, you must have something to hide. And then another thing that I think would have been really good to have on the, for the reason to have video in this case is because there are some issues regarding some websites that this person visited on his phone. And again, I've said it before, I'll say it again. If you are planning on committing a crime, you should not use any electronic device associated with you to do any part of the planning or preparation or research or anything like that, because they're going to find it and they're going to use it against you. Well, what SLED found on the phone was that he had visited dating websites in the weeks before this murder or this killing, because until a jury speaks, it's not a murder, it's just a killing. There had been numerous times when this phone had visited the website, and the state's theory is that he was looking to find his wife's dating profile so that he could follow her and catch her in the act of having an affair. But the only problem with that is that there is something called foundation. And one of the problems that the state has in this case is they have to show that it was him using the phone. And the state can't do that because they can only show when the phone was accessed. They can't tell who was doing it. And one of the things that the defense is saying is, well, you can't tell if that was his daughter perhaps checking out websites for dating, because he has the daughter of an age who might be willing to use dating websites. And indeed, the state could not disprove that. And of course, the plaintiff, or sorry, the defendant doesn't have any obligation to prove anything. All he has to do is call into question the state's evidence, and that seems to be doing pretty well. What I'm really confused about is why the judge admitted that phone evidence in the first place. Because generally speaking, there has to be a good foundation for admitting it, and if you can't show that that phone was in his hands at the time that those websites were accessed, it should not be admissible for lack of foundation. But apparently the judge admitted that. And then one of the things that comes up, as I said before, you have to have an immediate, unavoidable, deadly threat. And an unavoidable deadly threat normally means somebody is attacking you, they're coming towards you, they've got their hand raised like they're going to hit you or they're going to shoot you or do something like that. Something that would make your reaction by firing a gun at them reasonable. And in the initial autopsy report, the autopsy professional, the pathologist who did the autopsy, said that the hand was raised. When she testified live at trial 7 years later, she recanted that from her original testimony. And in fact, she said the bullets indicate that he was facing, or the bullet tracks indicate that he was facing away from Leone at the time that he was shot. Now that's explainable in closing statement by saying, look, when the guy pulled out the gun and got ready to shoot him, the guy turned, which is exactly, that's exactly what any of us would do. If somebody's got a gun and they're starting to point it at you, you're going to run. And generally that means you're going to leave as little of you around as possible to be hit. So that makes some sense, at least in terms of the defense. And the defense seems to be doing a very good job of calling into doubt the case made by the state. All that said, I have to say that I think self-defense in this case would be a very, very weak argument. One of the things that allows people to claim self-defense is having clean hands. In other words, there's nothing else going on. So when you're sitting at home on a day when it's nice and bright and sunny outside, 3 o'clock in the afternoon, and somebody kicks in your front door, and you grab your pistol and you say, you need to get out of here, and they come in with a knife and they're getting ready to stab you and you shoot them, self-defense is a really great defense in that situation. Because Present, unavoidable, deadly threat, an attack coming towards you, you shoot. Now, as I said before at the beginning, if that guy also happens to be the person who's having an affair with your wife, now you've got a problem. And of course, if you know that, it would be far better to make him pay for the door than to shoot him. Uh, there are so many things you can do in a relationship and in dealing with other people that don't involve violence and that are much more effective in the long run. It just makes sense not to do things that from which there is no return. Once you pull that trigger, once you shoot someone, once someone dies, somebody has to be accountable for that. And unfortunately, or fortunately, depending on how you look at it, if you have a relationship, if there's a relationship issue, if somebody is invading what is your province, your marital bed, if they are having an affair with your wife, then there is at least the presumption that you might be more angry about that than something else. You might be more angry about that than the fact that you think he's attacking your wife. If indeed he's having an affair with your wife, it's probably not, screams of agony that are coming from the car. It might be other kinds of screams. What somebody once referred to me as church services. The bottom line is, where there is conflicting evidence, and particularly about relationships that might be in question, self-defense is a very bad defense to make. Now, will he get to make that defense? Clearly he will. And will he be successful in that case? Well, only a jury is going to be able to tell us that. But you can go to 19 WLTX, which I think is the local station there. They've done a good job for the most part with some of their coverage in this case. I have to say, however, that I am always annoyed when people who don't understand the legal system report on the legal system. One of the things the young lady who is reporting on this trial talked about is how the defense made a motion to dismiss. That's not what they did. At the close of the evidence, there is always a motion for a directed verdict. What a motion for directed verdict is, a motion for directed verdict says, based on what the state put forth in their case, they did not prove all the elements of the crime beyond a reasonable doubt, and you should take this case away from the jury because there isn't enough evidence to convict me. The young lady then said, the judge dismissed that motion. That's not what he did. He denied that motion. Dismissal is a term of art in the law, and you don't dismiss a motion to dismiss, even if that's what had been filed, and you don't dismiss a motion for a directed verdict. You deny it if you're a judge. That's sort of my pet peeve about how these people report on things. You may wonder why somebody would make a motion for a directed verdict at that point. The shooting was on video, so there's plenty of evidence that the killing took place and that this person did it. So you know that part. This is not a whodunit. This is not, gee, who killed this poor guy? This is, this guy killed him. Why did he do it? Was he doing it legitimately to protect the life of someone else? Or was he just really ticked off that he was having an affair with his wife, or he believed him to be having an affair with his wife? That's what the jury has to decide in this case. But again, let me explain why they filed this motion for a directed verdict. A motion for a directed verdict is a prerequisite for a motion for a JNOV, which is a judgment notwithstanding the verdict. JNOV is an acronym. It stands for Judgment Non Obstante Verdicto. Non obstante verdicto simply means notwithstanding the verdict. And a JNOV is essentially a judge overruling a jury. Usually what judges like to see happen is they like to see a case go to the jury and the jury acquit if they think there's really not enough evidence. And then that way they don't have to take it away from the jury, and the jury's presence there and their being present in the courtroom for, 5 or 6 or 7 days in this case, weeks in the Murdaugh case, is sort of honored in that regard. But the JNOV is a very powerful tool on appeal because you can make the motion at the appellate court that the court should have granted either the motion for a directed verdict or a motion JNOV because there was insufficient evidence, and you narrow it down to one particular element of the crime or the fact that you proved all the elements of your affirmative defense of self-defense. But that's why they make the motion. It isn't because they really expect the judge to grant the motion. It's just something they do in order to preserve rights later on to get a different result. So hopefully that explains why they did that. It should go to the jury today or tomorrow, I think, for closing statements and jury instructions, and then the jury will have to deliberate and reach a verdict. But that's what I have for you today, a little bit of a report on that Greg Leone murder trial. If you have any questions, or if you know where there is additional video or something like that which could make this video a little bit better, I'd love to hear from you. Please leave it in the comments down below. Like, share, subscribe, and remember, this was a video that was proposed by one of the subscribers. If you have a request for a video, send me a message that says video request in the subject line, and then tell me what you would like to see a video made about. Thank you so much for watching. If you have the opportunity today, reach out and be kind to someone. Have a nice day, folks. We'll catch you here next time. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.